Hello and welcome to the University of Florida Levin College of Law, where we're here getting ready for the 10th annual edition of the UF Law eDiscovery Conference. My name is David Horrigan. I'm Discovery Counsel and Legal Education Director at Relativity, serving on the Planning Committee here and alumnus of the law school. We're pleased to welcome one of our keynote speakers for this year. It's the Honorable Tanya R. Kennedy. She is Associate Justice, Appellate Division, First Judicial Department of the New York Supreme Court. If you've been to the conference before or any tech conference in the law, you've probably seen Justice Kennedy. She's been keynote speaker at ILTACON. She's a member of the Relativity Fest Judicial Panel. And here at the conference this year, we've got a special treat. Her keynote is going to be Unlocking Innovation, the Power of Inclusion and People at the Crossroads of Technology and the Law. Justice Kennedy, you've got some important topics here, not only inclusion and diversity, a big one, but technology and the law. You've been quoted in Legal Tech News on this topic. First, let's start with inclusion and diversity before we get to the tech and the law. How has this shaped what you do on the bench? And give us a preview, if you don't mind, of what you'll be talking about next week.
David, Happy New Year. It is so good to see you, and I'm looking forward to being back at the law school. And this time, it's going to be in person, so I'm really excited. And, you know, innovation, as I indicated in the little summary, it really opens the door to new opportunities and growth. And just in my experience, when we talk about inclusion is really ensuring that people from all walks of life, that they feel respected, they feel valued, that they make a difference, and to certainly incorporate their talents and skills so that the organization can benefit. And certainly, I'm happy to say that I've been privileged, and I'll just focus on my current position, that as a new justice, someone obviously different background than my colleagues, certainly age, et cetera, et cetera. Certainly, when I give my opinion to my colleagues as we're discussing cases, I certainly feel heard. I certainly feel valued. And certainly my viewpoints are considered when we are deciding cases. And I'll be talking more about that. That's just a preview. Is that good, David?
That's absolutely great. And tell you what, let me do a follow-up if you don't mind. You're going to be talking about technology in the law as something that is a vehicle for inclusion and diversity. How can technology help us in the area of inclusion and diversity?
Well, David, you know, I'm a fan, and I believe that technology is really the equalizer, and that it can advance access to justice in spite of the digital divide. I understand that exists, but nonetheless, I think it makes things more accessible. The issue is, as it relates to the attorneys and certainly the people that work along with them, we must be aware of the platforms. New platforms are introduced each and every day. The issue is the law cannot keep up with the platforms. Another issue is that, do we know how to use the platforms? David, if you remember, just this past fall, we talked about sanctions, right? Because unfortunately, things were not preserved. A lot of that had to do with not understanding the technology, not being aware of the data that exists. Who are the custodians? Who should be responsible? Then you have the inadvertent disclosure. And so it all boils down to competence, but we can go even further, because I know that a lot of times we talk about Judge Matherman's decision, right? The EEOC decision. Am I right about that?
You're right about that.
Where,
Jumbo supermarkets.
right, where certainly, if you're going to supervise, right, if you have to ensure that the discovery is being produced. You just can't take the client's word for it. There are ethical obligations as well that we talked about that we saw in that case. Also, if we're talking about vendors, you're using certain vendors. Are you supervising them? Are you supervising the legal professionals that work with you? I'm not a fan of lawyers, non-lawyers. I like legal professionals, legal staff. So are you supervising the legal professionals that work with you? So all of these things, but the firm foundation is 1.1, right? Competence, because then it flows 1.4 as far as inadvertent disclosure, right? Then 5.3 as it relates to supervision. But for me, the way I see it, the foundation is competence, knowing the risks, the benefits of technology. And certainly, it doesn't mean that you have to be an expert, in this area. You just have to have a familiarity. And if you don't, then you need to retain professionals, tech professionals who can provide that knowledge for you. That's my answer, David.
Justice Kennedy, there was a lot of wisdom in there. I noticed when you were speaking, you quoted comment 8 to Rule 1.1. You made a reference to the California ethics opinion. So you've got it all in there.
498.
You've got it. And here's a follow-up question for you. You give a fresh perspective because you are a state court jurist.
Right.
In addition to that, you've also been a trial level judge and now an appellate justice.
Right.
In the trial court, did you find much of an issue? I assume that in trials, you may have seen litigants from all walks of life coming into your courtroom. And did you see technology as something, you've already mentioned that technology could be the great equalizer, but did you see issues among some of the litigants where they didn't have either access to technology? One panel we did, you'll recall, we talked about a case in Colorado where there was no internet connection. The gentleman had to go to a gas station to get wireless. When you were on the trial bench, did you see these things happen a lot?
Somewhat, David, somewhat. And if I may, I want to go back to my other answer because it's all of the above, but also when I talked about 498, formal opinion 498, right? A virtual practice is here to stay. And I think that for many lawyers and legal professionals, I'm not sure if a 5-day work week is really realistic. I'm not sure that's really happening. I think more often than not, that it's maybe a 3-day work week. I know with some positions, you have to have a 5-day work week, and I understand that. But I think it's more likely than not, perhaps it's 3-day. Maybe it's 2, but maybe 3. So certainly more individuals are working from home. So what does this mean? This means, do you have the proper security mechanisms in place? I know this is something that I had to do when I was elevated to the appellate division. It was virtual. So I had to make sure that my house was in order.
The Honorable Tanya R. Kennedy, Associate Justice of the Appellate Division, First Judicial Department, Supreme Court of New York. And once again, she will be giving the keynote, Unlocking Innovation, the Power of Inclusion and People at the Crossroads of Technology and the Law. Justice Kennedy, thanks for taking a few moments to join us today, and we're going to look forward to seeing you at the University of Florida.
David, it is always a pleasure, always a pleasure.
Thank you, Your Honor.
Thank you.